I want to introduce Sherwin Belkin, specializes in real estate and landlord-tenant matters. He has co-authored a complete guide to sublets and assignments. He authors the column Real Estate Review for Real Estate Weekly and writes articles on real estate law published in numerous industry journals. He will address purchasing occupied townhouses and vacating them for family use. We recommend Sherwin regularly, and his firm. They do transactions as well as representing landlords with tenant situations. So Sherwin, if you'd take it away.
Thank you. I've been doing real estate landlord-tenant work for about 35 years. My firm does real estate. That's all we do. On the residential side, we represent landlords, developers, sponsors, lenders. We don't represent residential tenants. Some people say I represent the evil empire. I think I represent the good guys. So that's the context with which my comments are made. In today's real estate market, townhouses are hot, and more folks are buying or considering buying townhouses or occupied apartment buildings, not just for rental income, but as a possible place to really expand family use. And what I'm going to principally be talking about is dealing with apartments that are occupied by rent-regulated tenants. So you understand rent regulation, there are two distinct types of rent regulation. Rent control, I think there are less than 90,000 rent-controlled apartments now. Those are generally in pre-war buildings, pre-1947, and have been continuously occupied by the tenant since on or before June 30, 1971. Rent-controlled tenants have an average lifespan of about 240 years, so that's why they can still, you know, that wasn't as good as your joke, I must say. I mean, that was one hell of a joke. Rent stabilization applies to buildings generally of 6 units or more. And dealing with rent regulations is a daunting prospect, but if you plan properly, the right to recover apartments for owner use is not just a right on paper. It provides a purchaser with a powerful tool and can lead to an expansive family residence. An owner occupancy proceeding is a proceeding brought by an owner against a rent-regulated tenant. In the proceeding, the owner asserts that the owner or a member of the owner's immediate family intends to take over that space to live in. The only entities that can bring owner occupancy cases are an individual, solo owner, or a group of individuals owning as tenants in common. Corporations can't, partnerships can't, LLCs can't, LLPs can't. If you're successful and you vacate the tenant, you could always switch the method of ownership afterwards. But to bring the proceeding, it's got to be an individual or a tenants in common. The rights are markedly different if your tenants are rent controlled or rent stabilized, and you need to know what they are. It's not enough if you're considering buying just to get the leases or representation from the present owner. That present owner can believe he has a rent-stabilized tenant. If they're rent-controlled, you've just bought a very difficult situation. For rent-controlled tenants, generally, you cannot bring owner occupancy proceedings at all. If you had one of the rare rent-controlled tenants in occupancy for less than 20 years, then you don't go to court, you bring an administrative proceeding at the Division of Housing and Community Renewal. And it's a state agency, it's a bureaucracy, it moves with the speed of grass growing, it will take years. For rent-stabilized apartments, it's completely different. You proceed via an eviction proceeding. And rent-stabilized tenants do not enjoy, like rent-controlled tenants, any blanket protection against owner occupancy. There is a difficulty when you're dealing with senior citizens or disabled persons. Senior citizen in New York State is 62, which as I hit 60, I'm resenting very much, but that's another issue. You need to know the date of birth of the stabilized tenants. If you bring an eviction proceeding and that person manages to drag the proceeding out and hit 62 while the case is still going on, suddenly there's a relocation obligation. And that also applies to disabled people. Relocation, as written in the law, is you have to provide the tenant with a substantially similar apartment at the same or lower rent in the same or proximate neighborhood. Now, as far as a rental unit for a rent-stabilized tenant, that essentially doesn't exist. What owners have done is offered to tenants, I will buy a co-op or a condo unit, move you in, you live there, I'll give you a life estate, you can live there for the rest of your life. Comes the end of that, you die, you leave, I get my apartment back, hopefully you've had an appreciating asset, and that's how they dealt with relocation. Or they moved the tenant into a free market apartment and agreed to subsidize the rent. So to win an owner occupancy case, what do you need to prove? The standard is good faith. Good faith has been interpreted by the courts to mean that the owner honestly intends to do what the owner has said they're going to do. In this case, in rent stabilization, you have to say that this apartment is going to be your primary residence in the city of New York for 3 years. Now, the 3 years can change due to unanticipated circumstances, but it's a 3-year requirement generally. Good faith means essentially, I'm going to be evicting this tenant, I'm going to live there. The concept being you're not using this as a ruse to throw your regulated tenants out and then rent apartments at market, that this is real. How do you prove good faith? Ultimately, the biggest thing is it's going to be your credibility. There's going to be a deposition, pretrial questioning, you're going to be served with subpoenas, the tenants are going to be looking into your background, your finances. It's ultimately the judge believing you. These cases are very rarely tried in front of a jury. It's just one person that's going to decide it. I encourage owners to try to avoid making this just based on testimony, he said, she said. There's nothing like a document. So if you've bought the townhouse and you're planning on, and you have 2 tenants in the building and you're planning on expanding your residence into those 2 apartments, retain an architect so that there are documents when you're testifying that you can show to the judge that make your testimony real. That's very key. Can you recover an apartment in any other manner? Absolutely. I reach out to tenants all the time saying, I'd like to discuss with you under what terms you would vacate. I don't pick up the phone and call tenants because A, it's out of the blue, and they're not prepared to talk to me, and I'm the 2 things that they hate the most, a lawyer and I represent the landlord. So, you know, it's like if I call, they can't, they just want to get off the phone. I'll send a letter to the tenant saying, I represent your landlord, I'd like for you to call me at a mutually convenient time and discuss your tenancy with you. And we'll talk. And I'll see if they're interested. And usually in my first conversation, I won't throw out numbers. I want the tenant to indicate to me they have some interest in going. Because if they say to me, how much? They've already reached step 1. They've already implied there's a number and they will go. And you know, the rule is when somebody says it's not about the money, it's about the money. It's a question of value to you of getting this tenant out and living in this home by yourself. For some tenants, this becomes a cause célèbre. It's my home. I'll be damned you're not getting me out of here. But then the sword of Damocles starts getting lower and lower, and the stands start running out, and the time starts getting shorter and shorter. And it's one thing to be very bold, but it's another thing to now be in court. Once a case is commenced, I would say 80% of cases result in a buyout of the tenant. Why? The standard's pretty low. You have to prove your good faith. That means unless the judge thinks you're really lying, you're going to win the case. If they're not a senior citizen or a disabled person, the tenant gets zilch. Here's an opportunity for them to get something. And the last big leverage is most residential leases have an attorney's fees clause in them, meaning if you serve the notice on the tenant, they don't vacate, you bring an eviction proceeding and you win. Now, not only does the tenant lose their home, get no money, pay their attorney for losing, but they get to pay me. Their attorneys will express to them, this is not a whim, this is not nonsense, this is something the owner really can win. Maybe you need to think about reaching an amicable resolution.